Welcome to another edition of the Briefing by the IP Law Blog. I'm Josh Escovedo.
I'm Scott Herbie.
What are we talking about, Scott? Are we talking about hip-hop copyright suits?
Yeah, today we're going to be talking about the long-running case that's been better known as the Empire copyright lawsuit. Its real name is Astor White versus Daniel Strong, but it's better known as the Empire copyright litigation. The plaintiff was Astor White, and the defendants were Fox and others involved in the creation of the television series Empire. That show was created by Lee Daniels, and it starred one of my favorite actors, Terrence Howard, as Lucius Lyon, who was a hip-hop mogul, former drug dealer, and CEO of a rap music label. And it also starred Taraji P. Henson, and also another fantastic actress, who starred as Lyon's former wife, Cookie, and she challenged Lucius for control of Empire Entertainment. Astor White claimed that Fox's TV series Empire infringed the copyright in a treatment that he wrote called King Solomon. So Astor White filed a lawsuit, and the defendants filed the 12b6 motion, and the district court granted the defendants' 12b6 motion.
And just to provide a little bit of clarity concerning the procedural language there, a 12b6 motion is a motion to dismiss filed under Federal Rule of Civil Procedure 12, subsection B6. And what it asks is, does the complaint state a claim? And for that purpose, the court looks at the complaint, it assumes that all well-pleaded factual allegations are true, and it asks itself, under the law, would this establish a claim? And if the answer is no, the court is required to dismiss the complaint. And generally, the court is required to provide the plaintiff with an opportunity to amend the complaint unless it's clear that amendment would be futile.
Yeah, and this is where the case takes on an interesting procedural twist. So the district court granted the 12b6 motion, but denied Astor White the opportunity to amend, so essentially ending the litigation. So Astor White appealed the early dismissal to the Ninth Circuit. This was way back in 2018. The Ninth Circuit said that although Astor White did not plead sufficient facts to state a claim for copyright infringement, the district court abused its discretion by denying Astor White the opportunity to amend his First Amendment complaint. I think that has something to do with the fact that he was a pro se plaintiff.
Right, and so what did the Ninth Circuit do? Did they remand the matter back to the district court, Scott?
Yeah, so back the case went down to the district court, and Astor White had 2 additional times to amend the complaint, but eventually the district court dismissed the case on the grounds that Astor White failed to state a claim for copyright infringement. So up it went again to the Ninth Circuit, where the Ninth Circuit upheld the lower court's dismissal. The Ninth Circuit's conclusion that as part of the extrinsic test, that the 2 works only share unprotectable ideas, concepts, and material that's in the public domain, and scenes that are sans affaire. And that's the part of the decision that I want to talk about today, the extrinsic test. The extrinsic test is used in the determination of substantial similarity, which is how we gauge whether or not copyright has been infringed. The extrinsic test is objective in nature, and it requires the plaintiff to identify specific criteria which it alleges have been copied. And this is where the court sorts out whether there is enough similarities between works as to elements that are protectable, because there are elements that are not protectable under copyright law. And if there are substantial similarities between those protectable elements, such that a reasonable jury could find that the defendant's work is substantially similar, then it passes the extrinsic test. Generally, the extrinsic test is only part of the determination of substantial similarity. The extrinsic test tends, it ends a plaintiff's infringement case only when the similarities between the plaintiff's and the defendant's work are either wholly due to unprotectable elements, or where the amount of similar protected elements is the minimus as a matter of law.
And is that where Astor White's complaint failed, Scott?
Right. The Ninth Circuit found that the only similarities between King Solomon and empire were forms of literary expressions that were unprotectable as a matter of law. The general idea of a story and all the situations and incidents that flow from basic plot premise are not protectable. So any similarities in the general plot, the themes, dialogue, mood, settings, place, characters, and sequences of events, those are all filtered out in the determination of substantial similarity.
So in this case, the ideas of a black record business mogul and his family, the inner workings of the billion-dollar record business and its effects on that family were a common thread between King Solomon and Empire. But aside from this, the court seemed to find that Empire and King Solomon are different.
Right, Josh. In the dissenting opinion to the Ninth Circuit's 2018 opinion, that's where the Ninth Circuit sent it back to the district court for the first time. The dissenting opinion pointed out the diverging storylines and the diverging character traits. The dissenting opinion objected to sending the case back to the district court and giving Astor White opportunities to amend his complaint. The dissenting opinion noted that the extrinsic test requires the court to review the works, to filter out unprotectable elements, and then decide as a matter of law whether the remaining similarities are sufficient to allow the case to go forward. The dissenting opinion said the district court did that.
Right. And so the dissenting opinion essentially says what we were discussing earlier in this recording. There is no point in letting the plaintiff amend the complaint, because even if he amends, the district court is going to have to strike this complaint down.
Right. And if you may recall the previous discussion that we had about the Costco and Tiffany case, we talked about that district courts should be should be cautious in ruling on dispositive motions in complex IP cases. But here's a case where, the Ninth Circuit said to the district court, well, you got the 12b6 motion right, but you shouldn't be in such a hurry to end his case and not allow him to amend. But 2 years later, the Ninth Circuit upholds the district courts, once again, the district courts granting of the defendant's 12b6 motion, probably after Fox spent, tens if not hundreds of thousands of dollars more on attorney's fees.
Right. It's a little bit of a catch-22, Scott. I mean, the district courts have to be weary of granting dispositive motions and ending the case, but all it really does is send the case back years later and hundreds of thousands of dollars more in litigation fees to reach the same result.
Yeah, I agree. Well, thanks, Josh.
Well, thank you, Scott.
Well, thanks for watching that video. Hope you found it informative. If you're interested in IP issues, please subscribe to this channel. And also, you should check out our blog at theIPLawblog.com.